Okay, should be recording. This is the latest meeting of the PCR Performance Standards Working Group, and Jordan is otherwise obligated today, so we can pick up where we left off. I have the running notes, so I will share my screen. I can find my cursor. There we go. Oh, that's the wrong one, I think. Hold on. And that should be the right one. I was on for most of the last meeting. Was driving, so I wasn't on screen, and then I watched the rest. I did have a couple follow-up questions before we start. Oh, good, Meg's gotten here. Hi, Meg.
Hey.
We were just getting started. I explained to Ed and Ginger that Jordan's doing something else right now, so I'm taking over for today. And I just pulled up the notes from last meeting, and I was about to ask before we move on. I think we were moving on to litigating claims was the next planned discussion topic, but I did want to ask before that a couple clarifying things about some of the previous things we discussed. So one was, um, I think it was last meeting that we talked about the need to be familiar with protective orders. And I've been trying to go through the notes, and I have a working draft that's more formatted. And I think Ginger, you were the one who mentioned this, and I didn't fully understand what that part meant.
Okay, so there's two different things with the protective order. So if opposing counsel asks for the trial counsel or appellate counsel file, then my firm requires a protective order for that. And that protective order is to prevent upon retrial
Oh, okay, okay,
the district
sorry.
attorney from accessing that file.
Yes, that part I'm familiar with. Okay, was there something else?
And then the second part, and I can't remember if it's covered somewhere else, but it's the stipulated protective, well, they're normally all stipulated, but there's a protective order for like child abuse records, other people's mental health records. So a lot of times the agencies won't turn over any records without a protective order. And I think the reason why we just made it really general, like K is because each agency has their own protective order that either they like to use or that they'll obviously have to sign off on. And so it can be a really complicated process in that, sometimes the attorney for CARES gets involved. Sometimes a victim's family may hire, victims' rights law firm to protect the record. So it can just get really complicated. So I think that's why we decided just to make K pretty straightforward because there's so many different variations of what can happen.
Got it. Okay, that's helpful. Thank you. And then I think when we did the investigation section, um, there was a lot of good discussion about what should be in it, but I, looking back, I couldn't find a point in the discussion where there was actually an identification of what the language around what the black letter should be before kind of all the enumerated stuff. I could just pull, I know for a while we were pulling some language from the OSB standards, and they have a black letter and then enumerated um, implementation under that. So I could use that, but I didn't know if the group had an opinion before I adopt that, or I can also just read out what that says.
I would like to hear it before I say I'd
Yeah,
like to adopt it.
yeah. Let's see, independent investigation. Upon appointment in a post-conviction case, counsel for petitioner should promptly begin an independent review and investigation of the case, including obtaining information, research, and discovery necessary to file or amend pleadings and to prepare the case for trial.
I think that sounds good. I mean, it's really doesn't really give you much guidance as a practitioner. I'm curious, what does is there like a criminal law section that's doing the same? I would be curious what their independent investigation section sounds like, because really they need to do that plus all the things we outlined.
Yeah,
I mean, if it wasn't done.
theirs is, if my memory serves, pretty long. Let me pull it up. I was just looking at it for another purpose. Investigation. Yeah. I mean, I guess it's a little bit general, but I can go back and see. I'll make a note to see if there's stuff we could think about adding in here.
So in terms of the performance standards, I'm guessing that it'll all be in one document. And so I'm wondering if maybe we could just can we refer to that section in the criminal law section for investigation?
That's an interesting question.
Because they need to be investigating whether or not there was proper investigation.
Right.
So they need to investigate whether or not those things in the criminal law section were done and do them if they weren't done.
Right. Actually, so I think, all these are getting adopted by the commission piecemeal.
Okay.
But maybe they will end up in a final single document. I think regardless, we could reference the criminal. I mean, the criminal one, I think what was adopted at the last commission or at the commission work group last week. So it will be in existence when these are done. And so we could reference it. Or we can take a look and decide if there's particular pieces we want to pull out or figure out another way to phrase essentially like do what the trial should have done.
Figure out what the trial attorney should have done. So Ed and Meg, am I making this too complicated?
Well,
No.
the bar book has a 3-sentence paragraph, and I think as far as the black letters, I understand we're kind of just doing a lead intro followed by more specifics. There's a couple sentences in the bar book's independent investigation counsel for PCR and habeas that may be useful. I don't know.
Can you tell me what it says?
Will you read them?
Yeah, and this is section 30.4-2 in the criminal law in Oregon bar books, and it starts with a lawyer who undertakes to represent a petitioner in a post-conviction or habeas corpus proceeding should independently review and investigate the trial proceedings. The review should, at a minimum, include the complete file of trial and appellate counsel. The lawyer should read the official trial record, obtain all discovery material from the trial lawyer, and meet with the client to explore all aspects of representation and the trial proceedings. And then after that paragraph, it goes into some more specific things.
I think that sounds better than the OSB little black letter bit, which is just so generic in general. It seems like if the black letter part is supposed to be the part that is giving guidance to OPDC on how to enforce these standards, having something super general is not especially, doesn't seem very helpful. or as far as like giving guidance to practitioners of like what the minimum kind of standard is. If
Yeah,
it's
I
just
guess
do an investigation, that doesn't seem helpful. So like bringing in some of the specifics seems useful. I don't know.
I don't like the part where it says at a minimum, because I feel like that is the problem with post-conviction, is that a lot of times that's what's being done, is to get trial counsel's file and appellate counsel's file. So I'm a little bit uncomfortable with that wording. I personally don't want that to be the black letter.
Like that's not enough.
I don't think so.
Yeah. Yeah.
And I fully understand that reason. It makes sense, Ginger. As I read it and kind of interpret it, is each cases are different. I mean, I do a lot of PCR guilty plea
Yeah.
cases that are
Yeah.
light and don't have a lot. So it just, and then you have a aggravated murder is going to be way different. So I just
Oh,
kind
I
of read
see
it
what
as,
you mean.
at a minimum, look at this stuff, but there may be much, much more. It may be a multiple trials. There was a mistrial, multiple trials. Yeah, I don't know. I'm reading it that way, but I totally understand what you're saying, Ginger, that, we want people to thoroughly review whatever the case entails, not cut corners, basically.
And I think that sometimes it's not that they're like lazy and cutting corners. I think that sometimes people just don't know.
Yeah. I wonder if we could phrase it as like a starting point, sort of more of like the requirement of doing a thorough investigation.
Begins with,
Yeah, kind of like begins by reviewing these things and then whatever else is necessary based on the case type.
yeah, and it would maybe be like then doing whatever else is necessary based on the criminal standards. But then I think we also want to incorporate that you can use the ORCPs to, I think I want to, that you can use the ORCPs to get more information than you could potentially have gotten in so maybe like utilizing ORCPs like in combination with the criminal standards. I don't know how to word it. It's hard for me just to um,
I know.
come up with something without writing it out. But Colin, do you kind of understand where we're going with it?
Yeah, I think that's probably enough for me to
Okay.
get a first draft of some language
Okay, perfect.
to circulate. That's helpful. Scrolling down at the end of last meeting, I think people were feeling comfortable with what we put in asserting legal claims and transitioning to litigating claims. I was looking at the OSB standards and noted that a lot of the stuff we've already put in here, they had put under litigating claims, which I think is fine. But I'm gonna, at some point, I'll probably flag to make sure that y'all are comfortable with having things in particular places and making sure there's not stuff that are in there that we want to also include. But other than that, y'all tell me what should come next under litigating claims.
Okay, let's see here. So are we talking about, let's see here.
Okay, so this is like trial memo, exhibits, and then calling
Right.
witnesses, actual like the hearing itself.
I think so. I think that's what I think at the end of last meeting, Jordan had put trial under litigating claims, and then you all said, well, I think this should include the trial memo, the response to the trial memo, and objections to exhibits. And I don't know if there would be anything else in addition to that.
Yeah, do we have like filing exhibits somewhere else?
Mm-hmm.
I mean,
Might probably not.
And then what about like expert disclosure and witness disclosure? I can't remember if that's somewhere else.
I don't think so.
Okay, that's a big one. Oh, and I just thought of something else that's not relevant to litigating the claim. Well, maybe it might be. I'll just say it and then we can maybe make a note of it. So the issue that we've been running into it maybe 2 or 3 times a year is where the petitioner has filed the petition before the appellate judgment has issued. And so what that does is essentially strips the post-conviction court of jurisdiction. And so it becomes, I mean, they don't have jurisdiction. And then the problem is that the federal and the state statute of limitations may have already run. So, you need to get an agreement from the state that they won't assert a defense for a subsequent petition or outside of the statute of limitations. Then you have to get your client to dismiss it, and then you have to refile. So I don't know. That's probably too much information. The biggest thing I think we should note somewhere is that when you get the pro se petition, you have to check whether or not it was properly filed, including whether or not it was filed after the appellate judgment issues. And it can even be a day early, and that is too early. The post-conviction court just doesn't have jurisdiction. And there's no cure.
If you file it before, there's no cure other than what you just said about getting them to
Right,
agree
right.
to the.
Yeah, exactly. I mean, there's no cure. Like the court can't say, oh, that's okay, we have jurisdiction. And the state can't stipulate to the court having jurisdiction. It's an improperly filed petition.
And then it would go after the appeal. You could refile, but you might be outside the timelines then. Is that what you're saying?
Well, normally the appeal is already over.
Right.
It's just that, the appellate decision is pending.
Mm-hmm.
And so they just get nervous and file before the appellate judgment issues. They just don't want it. They're so concerned about that 2-year statute of limitations that they just go ahead and file without understanding they have to wait until the appellate judgment issues. And, I explain to my clients, like, most of the time in life, being early is a good thing. This is a situation where it's not helpful. It's just counterintuitive in my opinion.
And then is the problem that you have not realized that is a problem until the statute of limitations has run? Like, how does the statute of limitations end up? Or
Yeah,
is it
so a lot of times the statute of limitations on it could have run. Like, for example, we got a case from another attorney who didn't realize it, and both statutes had run.
Got it. Yeah.
Because if it's improperly filed, it's not told.
If you don't catch it.
And it's an easy fix because the Department of Justice has been, gracious in waiving any defenses based on an early filed petition. But you have to ask for that and get that. I would recommend getting that agreement from the state before you file, or before you dismiss their petition. So you dismiss their petition, refile, and get the filing fee waived. So like I said, this is more like practice tips, but I do think that we need to I think a practice standard should be that you always check to make sure that it's properly filed, and to be properly filed, it has to be filed after the appellate judgment issues.
Generally, you're getting appointed
to
cases.
Sorry, go ahead, Meg.
Oh, generally, are you getting appointed to cases like the initial attorney getting appointed soon enough that you could, like, the statute of limitations has not run, and so you could just dismiss and refile?
Yes, exactly.
So as long as you're checking right away, it shouldn't be an issue if you're the initial PCR attorney.
Yeah, and then I think the practice.
Yeah,
exactly. The practice tip should be that if that happens and you're filing a subsequent petition, well, it's still subsequent is a problem. So you still have, the state still has a defense.
Okay.
Oh, even if it was improperly filed,
yes, it's
and
still
didn't have jurisdiction, it counts.
And I mean, I think if they didn't agree to not move against it as a subsequent petition, then maybe there would be an argument why it isn't a subsequent petition, because you would argue like that whole, I don't know, like that it wasn't right. Like I think you could maybe argue against it, but I think you should just get the stipulation from the state. And as of now, they've been completely fine under those circumstances, allowing a subsequently filed petition. But then it also, like I said, the filing fee is what, $285? So I always ask the court to apply the first payment to the second post-conviction or waive the second post-conviction filing fee.
Does
Like I
this
said,
maybe
again,
go in asserting legal claims?
I
I'll just I can
think
figure out a
so.
way to put it there.
Is there,
Or like something to check, should that be even earlier? Like when you get appointed, something to practice with of like,
Yeah,
so,
I was looking earlier. I didn't actually see. I mean, we have client communication and role of counsel, but
I
other
see.
than that, it seemed like the first section where it might make sense, unless it's kind of investigation to like look at all the dates. But it seems more like the process of asserting legal claims and thinking about your amended formal petition, or the formal petition includes the date checking process.
well, what is this section before asserting legal claims?
Investigation.
Or could it go in role of counsel? Like just making sure that it's properly filed? That seems,
Yeah, I like that.
Okay,
I don't know, totally crazy.
just make a note. Back to that.
Yeah, I don't think we didn't discuss, for example, statute of limitation because it starts with a pro se petition, but I mean, it kind of fits into that both
Oh,
statute of
yeah.
limitation, making sure it's filed within the period of time. I mean, we may want to say something about, being prepared for a defense that's not timely, and then also your point, Ginger, about is it
Mhm.
actually does the court actually have jurisdiction?
Is that something we included? I wasn't here last time. In the asserting claims, did we make a note about statute of limitations and successive petition?
Mhm.
Felt like we talked about escape clause, but
Yeah, just because you have to put that in the petition of why you qualify.
yeah, why plead that?
Which does, yeah, occasionally get left out and makes it just a little bit more complicated.
Um, you just said something about escape clause.
Yeah, you just need to assert why you qualify for the escape clause, whichever one, if you need to.
Yeah, but it shouldn't go under statute of limitations
Right, because it's either,
because yeah. So Meg and Ed, are statute of limitations, defenses, subsequent petition, defenses, those are all affirmative defenses. Is that right?
you have to plead in the petition why, if it is untimely or successive, you need to plead in the petition why you qualify for the escape clause.
Yeah, no, I understand that. I'm just saying,
Sorry.
can
I
we have
think
a,
it's jurisdictional, Ginger. I mean, I see them in an answer like as an affirmative defense, but
right?
I think it's jurisdictional. So
Okay.
I don't know that that
Okay,
would
so we
truly
can't
be
just
like an
have,
affirmative defense.
okay, we can't just have a section that says be familiar with like how to defend against affirmative defenses, because that doesn't encapsulate everything
Right.
we're talking about. Right, okay.
I think so, yeah.
Um, let's see here. So I think that what we were just talking about what you need to plead in the petition needs to go up in the first bullet point underneath the formal amended petition.
Okay.
Yeah, and I might say something like, if the petition is being filed outside of the 2-year limitations period, or is a successive petition, then you need to plead why you're whatever. I don't know. Now I've lost my ability to construct a sentence, but
Why you fall within the escape clause.
escape clause, yes, there.
So other than successive and outside the statute of limitations, are there any other, what other things fall on this? What other things would require you to use the escape clause? I think that those are the only,
Yeah, if it's like a
Two.
claim that could have been raised, if you had
That's
a
gonna-
direct appeal and it could have been raised in the direct appeal and wasn't, or if it was
Like-
raised in the direct appeal, those are issues you also have to deal with, but I don't think,
Would that be a Palmer bar? I know we
Yeah.
talked about Palmer bars and some other
And I
issues.
feel like
Yeah,
that-
we can-
I don't know. Do you think that, I don't think that has to be in the petition. I think that's different.
and I think it might change.
Yeah.
Depending on the actual innocence thing, because no, I guess Palmer is used for more than just actual innocence, but
Yeah.
I think we should just maybe put a pin in this and think about if there's anything else that we need, anything more complex that we need to alert people to that they need to plead. So whether, yeah, and if it's actual innocence, I'm sure that there's going to be specific pleading requirements for that.
That's true.
But it's all going to be based on whether or not it's pled. I mean, it's just all based on the ORCPs, whether or not it's pled sufficiently to give the other side notice. So maybe we're just getting too far out in the weeds and people just need to review how to properly file a civil complaint.
Well, I
Okay.
put a note so we could come back to it.
Talk about it later.
And I'll just, yeah, and Colin, I'll throw it out there. The bar book 30.3-5 is PCHA procedural bars. So,
Okay.
just for reference, because like I think, for example, I don't think the res judicata, I mean, I don't think you can I don't think you can get an exception, like you can with the successive, or
Sure.
I don't think there's an escape
Right,
clause,
right.
but that's where they go through their analysis of.
Yeah, so that might be more of a like, I don't know, maybe it doesn't need to be in there at all, or in the like litigating claims kind of area of just a note.
So Colin, do you sit in on other meetings like this?
I sat in on criminal. I ran, after KO left, I ran delinquency.
So
I'm
are we
still
getting
there.
too much into the details?
Question.
No. I mean, I think it's so hard to say. Like some things
Okay.
in the criminal side were very general. I mean, the criminal and delinquency were both modeled very heavily on the OSB standards, but the OSB standards for both of those were like 40 pages long. So they were starting from a more robust
Uh-huh.
model than the PCR standards. And even with that, like I was just looking at the investigation one, and my memory was that it was very detailed, but in reality, it's only, I think, slightly longer than what y'all came up with. But then like the initial client interview one was like 2.5 pages long. And it's like,
Okay.
you should ask about this, and you should ask about that. And so I don't think there's a right answer to how detailed
Okay.
this should be. I mean, as Meg, you referred to earlier, like the commission is also struggling with the question of like, what's the purpose and how much can we enforce any of this? And so they both want there to be minimums and want there to be also aspirational parts. But in reality, drawing that line is nearly impossible.
Okay.
And so what was approved for criminal, they ended up wanting to change the language from, they ended up wanting to change like best practices to commentary because they thought best practices still might be misinterpreted as you could be sanctioned if you don't do it. And I think there's lots of stuff in what ended up being called commentary that lots of lawyers would say, well, you got to do that in every case.
Okay.
And so there's not going to be any easy way to necessarily have to slot things in the right spot. So the more we can just, the more that's there as potential guidance for what you should do and ways that OPDC in the future could tell lawyers, this is what you could be doing to be better, would be good. And then the black letter, I think Meg was,
Yeah.
I think was fair to point out that if it's just too general, then we'll never be able to say like, well, this lawyer was not doing the bare minimum, so they shouldn't get PCR cases or they should have a lower contract or something like that. And so if we can have, if there's any way we can draw lines to say, well, if you don't do that, that's, you know, that's inexcusable, then that should go in black letter. And the other stuff that, even if it's stuff we all think should be done in every case, if it's not that, then it probably goes in the commentary.
Okay. So in terms of litigating the claim,
Yeah, I don't know if there's more categories or if we want to look at the categories that are there and then decide which should be first and how to flesh it out.
I think we should just start in on it and then add as if we think of anything.
Okay. Does that mean, does the trial, oh no, which comes first, the trial memo or exhibits or expert disclosure?
All of that stuff comes before the trial.
Yeah. Do the witness disclosures and exhibits come before the trial memos?
Yes.
Like that?
Not, yeah, let's see. Well, we can just go through it and figure out. So expert disclosures, there's a specific PCR statute that requires disclosure. 60, did we figure out last time that was 60 days before trial?
Well, it's 138.615, and it does refer to request of the other party or court order. I think
Yeah.
Marion County has a routine scheduling orders, but not all the courts
Yeah.
do.
Oh,
We
yeah.
may want to refer to 138.615.
I think that's right.
Yeah, I had made a note to myself that that I'd forgotten to ask about, which is I couldn't find a reference to 60 days in the PCR statute.
Yeah, we just,
I think the UTCR does say so. I can pull it up, and I think it says timing wise, but the statute and when the request comes would trump that. But let me pull up the UTCR.
well, Ed is looking for that. I think the most important thing about this is if they get a request for production for witnesses or expert witnesses, I guess it would be the witness list or expert reports. You have to if you don't object, then you have to comply with that. And failure to comply will result in that evidence being either excluded or continuance.
Okay, the UTCR 24.060. It's one sentence. unless otherwise ordered by the court for good cause shown, the disclosure of witness information required under ORS 138.615. So it assumes there's a court order request, must be made no later than 60 days before trial. So obviously, if you don't get the request within 60 days, I mean, I've seen this. I haven't had this like litigated. It's just kind of been like, well, if I got the request 30 days before trial, I'm compliant with the ORS despite the UTCR.
Yeah.
Is there anything else that needs to be said about the disclosures? Or just the fact that they need to be made in on a particular timeline?
Or even compliant with UTCRs and ORS and UTCRs rather than the specific timeline.
But doesn't UTCR 24.060, does it say the 60 days?
It says
60 days
required
and less.
under 138.615 must be made no later than 60 days before
Right.
trial. But the UTCR could change next year. I mean, that's what if we were to say compliant with.
Oh, I see what you're saying. And I don't know, do we just want to make a note that the current UTCR says 60 days? Yeah, because that's a good point, because who knows, maybe it goes to 30 days or maybe it goes to 45. Like if that UTCR is amended.
Well, and see, and for me, I take what I had in my criminal practice too, is I don't necessarily know who the witness is going to be. I mean, sometimes when I get the defense trial memo 20 days before, then I'm like, oh, this person's a witness. I'm going to add them and I'm going to put them in there and I'm going to explain to the court, well, yeah, I didn't know this person was a witness.
It's so complicated all of a sudden because now half the AAGs are objecting to stuff on foundation. And then half of them aren't. And so now we're having to list every single author of every single police report just in case they object to it on authentication and foundation. Basis. And if that happens, then you won't be able to do it 60 days ahead of time. But I don't know. I think it's complicated to encompass everything that will come out.
Yeah, I think when every trial becomes a 5-day trial with the 20 witnesses, maybe they'll come around. But I have no problem. I mean, that was my practice before I got bullied into 30-minute, hearings. And
yeah, we might want to revisit that last bullet point. I'm hoping that they stop doing that, but I definitely agree with the first three.
Should we move on to exhibits, or is there more to say about experts or witnesses? I assume with experts you're having to disclose their CV and their reports, but I don't know if that's just assumed as
the
part
rule
of the...
gets into rule requires opinion.
Yeah, just
disclosure. Subsection 2 says, unless otherwise ordered by court, disclosure required concerning any witness that a party may use to present evidence under, and then they're referring to expert witness, must be accompanied by a written report that is prepared and signed by the witness. So they're requiring, and it details, so they're requiring, a proffer, expert witness opinion proffer, not just if you have one, but required to provide one.
But I think the question was, does it also require CV? And it doesn't sound like it does.
No, the information for all witnesses is contact information. Yeah, I think just contact information. So
Right. Well, we can always come back to experts
Yeah.
if we want to add any more. Anything, what goes into the exhibit filing?
So for the exhibits, you're going to have the exhibits that are attached to your original petition. And then, you'll have any additional exhibits for your trial memo. And do you want me to say what those additional exhibits could be? Or, so things would be like declarations from a witness. That would include the declaration from your expert that you attach the report to. An important piece about the declaration is the declarant has to say that, assuming that you're showing information that could have been presented at the first trial, you have to put in the declaration that that person was both available at the time of the trial to testify, and if they would have testified, their testimony would be consistent with the testimony in the declaration. And can you put another little note on to see if, well, maybe this goes here about the witnesses, that you have to make sure that the witness, for example, expert was an expert at the time of the original trial, and that the information you're presenting was available at the time of the original trial. Unless it's actual innocence.
Sorry, the last part you said was the information must have been, the information about which they are an expert must have been like, current,
Yeah.
essentially.
Yeah, so
So
for
like
example,
evolving science won't matter if it wasn't science then, unless you have an actual innocence claim.
I think so. What do you guys think? I mean, we've had new science information struck from cases before, but I don't know if that's really changed. If I don't know, what I do is I make sure that any reference, like if my expert's going to say I would have testified to this at trial, then they need to only be used, like if they're referring to a scientific paper, that scientific paper needed to have come out before trial.
Mhm. Is this always or assuming that the basis of the claim is ineffective assistance?
I think that would be the right way to qualify it.
Yeah.
And maybe we could reach out to Janice Perkel and just maybe get a little bit of information with regard to how you use new evidence. But I think I'm sorry, not new evidence, but like new scientific stuff. Where I think that comes in, where I've used it, is in a DNA petition. And I think it's going to be the same for the actual innocence petition.
I've seen some like just standalone due process
Okay.
claims that are like you were convicted based on faulty scientific evidence. I think I've seen like 2 of those. So
Yeah.
they're,
So
But
like-
that's not necessarily tied to actual innocence.
I mean, like very closely related, but not exactly.
Okay.
Yeah.
Is that just because the actual innocence statute has really high standards that you
Well,
might
we don't
not be
actually
able to
have
meet?
one yet. We're
And because
just
we don't
hoping.
have an actual
Oh,
innocent claim yet.
Okay.
Yeah.
Got
This
it.
is just fingers crossed type of stuff.
Yeah, exactly.
Um,
Yeah, I don't know if that would change, if those would just turn into just straight actual innocence if we
mhm.
had that established as a claim.
And so for the declarations that you were talking about a second ago, is that mostly, do you include the declarations because you're hoping that, because that is the testimony you anticipate coming out at the trial, and that would be a way to have essentially summary judgment on an issue? Or do you have to have a declaration from, like, what is the other purpose for having a declaration? Is
You
it
can have a declaration instead of testimony.
Yeah.
At trial.
okay? But there's not like you don't have to have a declaration for a witness if you'd rather have if you anticipate going to trial and you'd rather have the testimony come in live. Is
Correct.
that
The
correct?
the defense almost always uses declaration as opposed to live testimony. And I mean, I take a lot of depositions, for strategic reasons. But yeah, I mean, they want to litigate them on declaration. I think the statute still says affidavit, but I've never heard, a pushback. But yeah, they submit it as testimony, and you know, I'll call them for cross-examination, but I don't think the court will exclude it. It'd be very hard to imagine the court excluding it, unlike in any other court setting where, they take live testimony.
Mhm.
Is there a practice or is there a best practice related to when you would have a declaration, like when you would choose to use declarations?
Mm,
The exhibit, you mean as far as filing or use of?
filing
I guess
one. For us, filing
yeah.
one.
Yeah.
Because I understand the UTCR, which is very specific about exhibits, that's going to be a trial exhibit.
I think I'm hesitant to put a practice tip in with regard to this.
It's just if you are going to use them, you have to do it and comply with all the timelines and rules around them. But we're not going to make any recommendation about whether or not you should.
Yes, because there's reasons to file a declaration and there are reasons to call that person as a witness.
Yeah.
But they're not mutually exclusive. You can file a declaration as well as call them to testify. The court doesn't love when you just go over the entire declaration in the testimony.
Yeah.
And I'm sure you could get a cumulative evidence objection, but those are mostly just to break up the testimony.
Yeah.
But I personally
guess-
don't put a practice tip in there about it.
I call just so you know, because this is so different from most areas of practice. The statute says the court may receive proof by affidavits, depositions, oral testimony, or other competent evidence. And I mean, I use like you would in a summary judgment. I use deposition testimony way more than live testimony, and I can brief it for the court that way.
Mhm.
But that's that's how it comes out. Very different from a lot of.
Got it. Okay. Is there more to say about the filing of exhibits or what exhibits should be included? Or
I might just put in somewhere in here, as far as the like witnesses and experts, if your claim is IAC for failing to call an expert or a witness, you must
Yes.
provide evidence of what that expert or witness would have said, or the claim will necessarily fail. And that, yeah.
that seems related to what you'd said earlier about
Yes.
having it be current at the time
Right.
of trial.
The like availability piece. Yeah, those are.
Yeah.
I mean, there's maybe not hundreds, but there's a lot of other exhibits you would. I don't want this to appear to be mutually exclusive at all.
Right.
Because you can,
You'd have a
like,
police
for
report.
example,
Yeah.
the police report, or I mean, OCDLA publications,
Hmm.
declarations from other attorneys about what they were doing at that time.
Hmm.
I mean, they're just so many different types of exhibits that you could file.
Yeah.
I would say, again, we don't want this to appear mutually exclusive. And in terms of the exhibits, I think that people need to know how to authenticate the exhibits and how to get them into evidence.
Well, I know there's a habeas meeting coming up in
Yeah,
5 minutes. I believe Jordan didn't ask me to to do that one, so I think whatever he was doing from noon to 1, he will be done with. So I want to give y'all a break before that, and if you'd like more than the 5
Okay,
minutes,
just
like it.
final note procedurally, the UTCR has a lot of little details about filing exhibits. It's 24.040. And I don't know that we want to include all the detail, but maybe some reference. And I haven't seen the court be too rigid about that, but there are definitely details I've found as of question about how things were done.
Great. All right. Well, that seems like a good place to stop and to pick up next time. And if any of you want me to message Jordan and ask to start 2 minutes after 1 for habeas, I can do that. Or
I'm fine.
It doesn't matter.
I can go straight on. Thanks, everybody.
Okay.
Thanks. See you in 2 minutes.
Thank you. See
Or
y'all in a
4
couple
minutes.
weeks.
Bye.